What is an independent administration? It is one of the forms of probate that we do in the state of Texas. Now, probate, so you understand, is the process. It's a legal process of transferring property from a deceased person to a living person. And there are about 6 main ways to transfer that property. The most common, and the one we try to seek to do a lot of the times, is an independent administration. There's also a thing called a dependent administration. There's a process called Muniment of Title. There's a small estate affidavit. There is a Determination of Heirship, and there are what are called heirship affidavits, which is a very common way of transferring property. Now, what is an independent administration? What that means is the court appoints an administrator and executor. An executor means there's a will, and an administrator means there's no will. They appoint an administrator to act independently of court oversight. Okay, so they're saying, hey, you as the administrator or the executor can go and handle everything. You do not need the judge to approve anything that you're going to do. So the most important thing is this is a process. So what is the process? What are the steps that you have to go through? So we help our clients go through these steps, but if you're with your attorney that you're meeting with, this is the steps that you'll need to go. Well, first, we need to draft and file the application. We have to apply to the court saying, hey, we want to probate this will, or we have no will, we have to do a determination of heirship beforehand so we can, name the heirs and who's going to administer the estate. The second step is we need to send out waivers to beneficiaries to ask them, hey, do you want to be involved in this process, or do you just want us to handle this process? We need to file those waivers with the court. After we file those waivers with the court, we set up a hearing so we can go to court, and it depends on what we're doing. If there's a will, we don't usually need very many people, but if there's no will, we're going to have a lot of people come and give testimony at this hearing. Okay. Let's say a beneficiary refuses to sign a waiver. Well, then we need to serve them, let them know what is going on in this process. Then after that beneficiary has a right to know when this hearing is going to be. We're going to have a hearing. At that hearing, if all the beneficiaries agree, if there's no will, then the court can allow someone to serve independently. A judge may go, no, I don't feel comfortable in this case. I want it to be a dependent administration, and then it would change to a dependent administration. But the judge signs an order at that point, and he issues what are called letters. Letters is an old fancy way of saying back in the day when someone passed away, a judge you're going through the probate process, he would write a letter telling that this person could go show a bank or a financial institution or anybody else in the world that this person had authority to act on behalf of the decedent. Okay, that's what letters are. Letters testamentary or letters of administration. After that, after the person is appointed, we file what are called notices to creditors. And then after 60 days after that point, we then file an inventory. Now, these 9 steps, most attorneys will help you through all 9 steps. Usually the attorney, they're charging you a flat fee, or whoever's helping you, it's to cover those 9 steps, because those are the 9 things that you need the attorney to help you with, because you cannot file documents on behalf of an estate. You have to have an attorney do that. You can't represent an estate, even though you might be named the executor. An attorney has to do it, of course, because you have to have a law license to do that. So the attorney will usually charge you a flat fee to cover those 9 areas and do all that. The second step is administering the estate. You don't need an attorney to do this. He got you the letters. He's finished everything up with the court. You can go out and administer the estate by yourself. Now, a lot of people, they want an attorney to help them with it, especially because the estate's paying for it and they're busy and they have a job. They just don't want to deal with it. You can pay the lawyer to do that, but that will usually be an extra charge on top. Administering the estate is usually billed hourly because we don't know how long these steps are going to take. But let me walk you through what you would have to do, and then you can determine if you want to hire an attorney or just do this on your own. First, you have to send out notices to secured creditors. Okay, secured creditors need to receive notice. You need to send a notice of appointment to the beneficiaries. You need to tell them, hey, I've been appointed here. I have authority to act on your behalf. This is what's going on. Then you have to send notice to the comptroller if there's any taxes that need to be remitted. After that, you need to determine if you're going to send notices to unsecured creditors. And that's just the determination of, well, do I want to let them know about this? What's kind of going on in that situation. You have to deal with if any unsecured creditors or secured creditors file claims in the estate. You're going to have to deal with those claims, okay? You need to file the publisher's affidavit, handle all unsecured claims, approve and reject those claims, and then distribute the property after you've given everybody a final accounting, okay? That's the process that you need to go through as an administrator of the estate. Like I said, you do not need an attorney to do that. It is an extra charge that attorneys charge for because they have no idea how long that's going to take them. If you have 30 creditors out there, it's going to take hours and hours and hours, and it's going to be a lot of money. Most people don't really have hardly anything, so they don't really need that service. I mean, there's no unsecured creditors, there's no secured creditors. So they just say, I'll just handle it and I'll go distribute the property. But that is an independent administration, and that's the process that you have to go through. And if you have any more questions, you can let us know and give us a call.